Good morning, YouTube. I wanted to hop on real quick and make a video, relatively short video, on the issue of a criminal arraignment, what a criminal arraignment is, and concerning that process, and then also what you can expect at your criminal arraignment. And I apologize, I'm trying to get my microphone free here. Just a moment. So, a criminal arraignment is the first formal hearing. Well, let me back up a little bit here. This video is brought to you by Briggs Law PLLC. My name is Craig Briggs. I'm the owner-operator of Briggs Law PLLC. I've been practicing in the area of criminal defense for roughly 10 years. I've also practiced municipal law, which when I did that included a lot of contract work in the area of public works, and some other things of that nature that you see crop up in cities, a lot of civil disputes, things of that nature. But the primary focus here is obviously a criminal case. In a criminal case, your first criminal hearing, so the first court appearance that you have, will be called an arraignment. Here in Washington State, where I practice, it's an arraignment hearing, a formal arraignment hearing. Again, the discussion here in this video is going to be relatively broad. It's not going to include specific examples of any specific cases. I'm just going to be speaking in generalities in terms of what to expect at a criminal arraignment based on the experience that I've had here practicing in Washington State for the last 10 years, and I actually do handle arraignments. I've been doing arraignments, that whole process, since the get-go. My first contract back in, what was it, 2014, 2013, that area, time frame. Okay, so let's get started. So your arraignment, what is it? So under the Constitution, you have to be advised of the charges against you. This is a part of due process. It's a part of your opportunity to be given notice. So notice is the big thing here. And then also an opportunity to respond to the allegations against you, of course. Most people have a defense, whether that's a general denial defense or if it's a specific statutory defense. Here in Washington State, you bifurcate those two things, which all that simply means is that if you were asserting a general nature defense, you would indicate that to the court on the record, as opposed to a self-defense argument, say in an assault case where you were defending yourself. Also, you would let the court know of that in advance of trial so the prosecutor could prepare their case accordingly. Now, at an arraignment, the judge's job here, as is the attorney's, is to do a couple things. First, they're looking to see whether or not there was a valid stop. Okay, this is the first thing that the defense attorney should be looking for, the prosecutor should be looking for, and the judge should be looking for. Is there a valid basis for the officer to contact you in the first instance? That's number one. That's based on reasonable suspicion. Okay, that's a very low-level standard. It has to be more than a hunch, but it doesn't need to be much. The second thing that they're looking for, again, is going to be a legal term of art. It's called probable cause, which basically means that the officer who makes the contact and follows up with an arrest or a citation has a reasonable basis to conclude that a crime was likely committed and you likely committed the crime. That's what probable cause. It's a higher standard than what we see with reasonable suspicion, but it's well below the standard of beyond a reasonable doubt. That's applied at trial, obviously, at the opposite end of this process of an arraignment. The arraignment's the first formal step. So there are two broad options at an arraignment. You have an absolute right, at least, in Washington State, and I believe in all 50 states, under the federal Constitution, have an absolute right to plead guilty in an arraignment. Okay, that's option one. That is a rare circumstance. That does not happen often. There may be instances where an individual is charged with a crime. I work primarily in misdemeanor district court, and let's say somebody is charged with a misdemeanor DUI, but it really should have been a felony DUI because of the history, right? That would be a case where I would have a discussion with that individual about the likelihood of refiling in superior court if the prosecutors figure out the mistake that they made. And so that might be an instance where that individual may, advise them a different route than what I typically would with an individual at an arraignment on a DUI charge. So there are certain times, and it's a preclusion issue from the prosecutor's perspective. They've had their one bite at the apple, and they made a mistake, and they filed it wrong on their end. Then they don't get to bite at the apple again. And this brings up another point here too. When you're charged, you can either be charged kind of in the field by the officer. Here in Washington State, officers can write criminal citations. If those crimes occur in their presence, they can write out a citation, which bypasses the prosecutor, right? The prosecutor is not the one filling out a criminal complaint. The officer is filling out a criminal citation. So that's one way you can be brought forward to an arraignment, is just strictly by the officer. The other way is, let's say the officer goes out on an alleged assault case between husband and wife, and they're not real clear. They have to make an arrest, but they're really kind of unclear of what the charges should be. Maybe it's a felony assault. They're not certain, so they arrest them, maybe book them on a misdemeanor charge, and then they forward the charges to the prosecutor. The prosecutor may choose to file up in felony court. There could be other examples where the officer just doesn't even make an arrest, is unclear whether or not a crime has occurred, and still forwards those documents over to the prosecutor so that the prosecutor can make that determination of whether or not they meet that, kind of low level probable cause standard. Again, a reasonable basis to believe that a crime was committed and you were the culprit. So if any one of those things happen, you will be brought before an arraignment. And again, option one is to plead guilty, which is a rare circumstance. So the vast majority, like 99.9% of individuals, are going to be pleading not guilty at their arraignment. This is typically what I'm advising individuals in court, to enter a plea of not guilty and then work towards a resolution with their private attorney or their court-appointed counsel if they can't afford one. And so after this process, you have two options, or actually three options. You have, again, under the Constitution, the federal Constitution, and even the state constitution here in Washington State, and probably most other states. Again, I'm speaking specifically to Washington State law, but I'd encourage you to look in your state law to see what the state constitution in your state says about this issue. But in Washington State, under the federal constitution, state constitution, have an absolute right to represent yourself as your own attorney. This is called proceeding pro se. Pro se just means you're representing yourself. That's all that means. And what I can tell you is that proceeding pro se could be a difficult task for most people, because they're going to be held to the same standard that an attorney's held to, that me myself am held to. And I've had the benefit of 4 years of undergraduate, 3 years of law school, and then I studied for about a year for the bar exam, passed the bar exam, and so you're at a disadvantage because you're going to be competing against an attorney in there in court that has had that same benefit that I've had. And on top of that, 10 years of experience, over 50 cases tried, right? This is an uphill battle for the pro se litigant. That being said, you're absolute right. I would just let you know that if you do proceed pro se, you're going to be questioned by the court in terms of your level of knowledge. So be prepared. If you're going to represent yourself pro se, do your homework. Go read up a little bit on maybe some litigation strategy, what the court processes are, what the relative jobs are, what the clerk does, what the judge does, what the prosecutor does, what the defense attorneys do, what trial looks like, how to cross-examine witnesses, right? So there's a lot of homework, I think, to be done if you really are going to do that responsibly and do your case the best service. But if you do that way and you learn, you certainly can do that. But just be aware that the court is likely to challenge that, at least through their questioning, to try to poke holes in your knowledge, to try to make you feel unsure of your ability to actually do that. So don't go in it unprepared if you're going to be a pro se litigant. That's the best thing I can give you is just go do your homework. Most people obviously are going to retain counsel. They're going to go out and hire an attorney of their choosing, whoever they like. They may have an attorney that they work with already that they're thinking about. And some of these individuals may actually show up at their arraignment with those attorneys. That's pretty rare from my experience. Typically, at an arraignment, people are unrepresented by counsel at that stage. So don't be panicked if you haven't found an attorney yet in your arraignments tomorrow. If you cannot afford an attorney and you think you would qualify for court-appointed counsel, you do have a right under our federal constitution for court-appointed counsel. That's in all 50 states. And the process there is different. And even in Washington state, it's different in every single jurisdiction I've been in. But generally speaking, what that means is that they're going to look at your financial resources. They're going to see in reference to the federal poverty guidelines where you sit. Within that percentage where you sit. Here in Washington state, what I can, and specifically in the county that I practice in, which is Franklin, Benton counties, Yakima County, Walla Walla County, in those areas, if you are on any kind of state assistance, whether that's food stamps, TANF, temporary assistance for needy families, whether that's state medical insurance, or some kind of federal counterpart, that's likely going to qualify you for court-appointed counsel. And at that point, they would give you that contact information. You reach out to that attorney. So again, this is kind of a nutshell explanation of what your arraignment is, what your process is. Again, when you get there before court, some courts are a little bit different. I know in Franklin County, you can go to your arraignment here in Franklin County, Washington. You really don't need to say much, if anything, at all. When I'm present there in court, I enter pleas on behalf of the individual clients. There's really not a lot of talking that the defendant needs to do. In fact, I would encourage individuals to, if you do have a criminal arraignment, really the only person you should be talking with about that case is your attorney. And remember what I said earlier, which is most individuals show up at an arraignment unrepresented by counsel at this stage. And so there's only really one person in that room that you should be talking to, and that's the standby defense counsel. Okay, so you want to identify who that person is. You certainly don't want to just go talk to the first attorney you see in court who might be a prosecutor, right? Before you start discussing anything, you want to know who that person is. If they're standby defense counsel, you really still don't want to probably discuss the details of your case because you're in open court. So at a minimum, you might want to step outside the courtroom and try to find a quiet place to chat real quickly. But the best thing that you can do is to speak on those issues with your retained counsel or the indigent offense attorney, the court-appointed counsel attorney that the court assigns to you. And that wouldn't come until after the arraignment. So really the arraignment's probably not the best setting to be discussing a lot of details of your case. Number one, it's in court. Number two, it's not going to be with your attorney that's going to be assisting you down the road, more than likely, unless you have the chance of maybe getting the court to assign the counsel that's there as standby, which does happen. So that's your arraignment. Again, the other thing that they're going to address at arraignment too is conditions of bail and conditions of release. And so here in Washington State, and again, each state's a little bit different, but here in Washington State, they're looking at two things, and it's probably roughly similar. But again, I'd encourage you to look at the laws in your state to see. Washington State, they're looking at two things. They're looking at, whether you're a risk to not reappear to court. So are you a flight risk? Are you going to not appear to court? You're going to breach your promise to the court that you're going to return. They're going to look at warrant history. They're going to look at maybe crimes of dishonesty, certainly crimes like escape or eluding police, things of that nature, which tend to show that maybe you could be a flight risk that would cause them concern about your ability to return to court. And then second, they're looking to see whether you're a risk to go out and commit a violent offense, if you're basically a risk to the community. And so, they're going to look at criminal history and see whether there are violent offenses in that history. They're probably also going to look at the facts of this case to see whether or not there's some allegation here on this case that maybe there's some violent action and there's an at-risk individual that could be jeopardized if you are released without a bail condition. So if they don't impose a bail, that would be what's called a release on your personal recognizance, or PR, or some jurisdictions call it OR, on recognizance. Just means that they're releasing you on your promise. Just be aware, in Washington State, as I'm sure it probably is in some other states as well, if you do fail to return on that promise, that could be another independent crime of failure to appear or surrender, colloquially referred to as bail jumping. Even though bail isn't imposed here in Washington State, the way they draft that law is that it's bail jumping plus a failure to return on a promise, which could be to a subsequent hearing in court, or it could also be for your sentence. Say you're convicted and they give you a date to return to the jail and you fail to return then. In addition, it would also include bail jumping, true bail jumping. Well, I hope this video was helpful to some of you out there. Again, it's your first formal hearing. If you're not court appointed or haven't found an attorney yet, don't panic. There's still time to do that. Just remember, the vast majority of individuals there are going to be pleading not guilty, not saying much. There's no requirement really for you to say anything. And then remember that the individual that you really want to be discussing that case with is your attorney, whoever you choose to hire, or whoever might be appointed to your case. Again, I hope this video was helpful to some of you out there in terms of preparing for, at least mentally, your criminal arraignment and what to expect there at the arraignment. And then I'll be making some future videos too on follow-up processes, the pretrial process, as well as what to expect at trial, how to prepare for trial. If this video was helpful to you, please leave a like, comment, consider subscribing to the channel. And if you're interested in a legal consult, you can reach out to me. My website is briggslawpllc.com. Have a wonderful day. God bless.